Welcome to Notable Approvals. I'm attorney Amanda Shaffer. I'm very excited to talk about our case today. I just got out of court, virtual court. Before I get to that, don't forget to like us and follow us on Facebook and YouTube, LinkedIn, Instagram, wherever you're watching from. And if you find this video to be helpful or know someone who may, please hit that share button. So today is a very unique case that I'm going to talk about. It is a family law case, child custody dispute. And it's something that rarely comes up, this type of situation. It happens, unfortunately, but it was let's just get to the facts. How about that? So this is about a parent, two parents. One parent lives in Canada, one parent lives arguably in New York. I say arguably because there's disputed facts about where she's resided over the past few years, but we do know since September she's been in New York. The parties had met in New York, and then they had a baby together. They lived together, had a baby together, and then they, as a family, moved to New Brunswick, Canada, which is a province in Canada right above Maine. Unfortunately, things didn't work out between mom and dad, and they ended up splitting up about 9 months later. Mom, a U.S. citizen, moved back to the States. She moved to Maine. And dad, a Canadian citizen, stayed in Canada. And at first, the parties had an oral agreement to exchange the child. Maine, where she was in Maine, wasn't too far from where he was, maybe 4 hours or so. So they were exchanging the daughter every 2 weeks. And then they ended up entering into a written agreement in 2020. Because of COVID, it made it harder to do it every 2 weeks. The borders were closed for the most part and all that. So they entered into a written agreement that basically said they're going to split custody of the child. And that the child's split custody of the child just down the line, and they were supposed to exchange every month or so. They agreed that Canada would have jurisdiction over any future custody disputes, and the agreement was set to expire December 31st, 2022, and it even said in the agreement with the anticipation that the parties will have entered into a new agreement by then, because the daughter will be of age to start kindergarten in the fall of 2023. Yeah, we're in 2023. So she would be coming up in this fall. So the parties had been doing these exchanges for 4 years, 2 without the written agreement, 2 with it. They never went to a court to enter it. They never had any issues exchanging the child. So in September, the dad meets mom in Maine. They exchange the child. She brings the child to New York. The child starts pre-K, and she's supposed to give the child back in December, December or something, like early December. Then mom asks, I think in November, can I have an extension because I haven't had the child the last 2 years during Christmas? So dad said, yeah, not a problem. I'll pick her up on the 26th. So they had an agreement, and we had text messages and emails and all that fun stuff showing that dad and mom was to meet dad in Maine on December 26th and give him back the child. And at that point, they kind of had established every 3 months they had been exchanging the child. The parties had not, though, come to an agreement regarding where the child was going to primarily reside and go to school. So we're in December, I think 13th comes around, which is actually my dad's birthday. And my client asks mom, hey, just want to confirm December 26th, 1 p.m., this is where we're meeting. And this was her first indication that something was off, because she says, I got to confirm with my dad. He says, okay. But then she never doesn't get back to him. Little did he know, while this was happening, that she actually she hired a lawyer in New York and filed a custody petition. Now, I'm not going to get into this whole boring, drawn out conversation or explanation of jurisdiction. I should have closed the blinds though, but basically, jurisdiction is one of those legal things that it's one of the first things you learn in law school. And you spend a year learning it, and it's really complicated. So there's all different ways you can get jurisdiction. And what I mean by jurisdiction is that you're subject to a particular court, that whatever the issue and the person can go to that court. So you can't go to family court and file criminal cases. You can't prosecute someone in family or even in a civil court. You have to go to criminal court. So you can't get a divorce in a criminal court. You have to go to Supreme Court. There's that type of jurisdiction. And then there's also jurisdiction over the person. If you've never been to New York and none of the plethora of jurisdiction provisions apply, you're not subject to personal jurisdiction in New York in many cases. So it gets really complicated when we're talking about jurisdiction. But essentially here, Mom said that there's something called the home state rule. And 49 of the 50 states have adopted this federal legislation to some extent and agree that wherever the child has resided for at least the past 6 months is their home state. And the home state gives the court or the state, the court in that state, jurisdiction to decide issues of custody, visitation, that type of thing. When a child has not resided in a location for the past 6 months prior to filing with the court, then that's where things get a little more complicated. Now, in this situation, when Mom filed her petition, she claimed that the child had been in New York for at least 6 months. However, that was not true. And we actually were able to prove that with physical documents. So lesson number 1 from today. When you're having disputes about child custody or anything or child support, or anything with your child, anything that could end up in a courtroom, phone calls are great. Record the phone call or put it in writing. Put it in writing is easier because you want to be able to back it up. So we got a call from this client and his Canadian attorney in December, once he realized Mom wasn't returning the child, even though she never said she was or wasn't. But her New York attorney jumped in, and suddenly there was this New York attorney who said that I can't advise my client to do this, and unless he signed a new agreement which gave New York courts jurisdiction. Now, there's a big difference. Now, it's about a 10-hour drive between that court and this court. And there's a big difference sometimes between which court you're in. But the biggest difference is that usually the party who's local has more of an advantage because it's easier, more convenient for them, even though sometimes it's virtual. But also, they may be able to retain counsel easier. The laws may be more favorable to some extent, even though in both jurisdictions the laws were pretty similar as to how it looked at child custody. And of course, as I mentioned earlier, she did agree to court in Canada previously. So regardless, so the question of who has jurisdiction can be really important. Now, I am always under the belief that it's not as important as people make it out to be, depending on the laws of the other jurisdiction. And like I said, in this case, the biggest difference was probably going to be cost, because it's more expensive to have a case in New York and have a lawyer in New York than it is up in Canada. I'm not saying that across the board. I don't know, but I believe in this situation that was a factor for both parties. So you have to be careful, because if you do not challenge jurisdiction immediately, you're waiving your challenge. And if you file something in a court where you're saying there's no jurisdiction, you may be conceding jurisdiction, and then that's it. So we also This is another thing. We couldn't do anything until mom didn't return the child on December 26th. And they couldn't do anything in Canada either because she hadn't violated any rights at that point. So, and it didn't matter, if you're wondering, that the agreement expired at the end of the last year, because the law says if there's no agreement in place, then there's joint custody in both jurisdictions, and the violation took place while their agreement was in effect. Now, here is a very important lesson number 2. Written agreements, I always highly recommend. Put it in writing. If you and the parent of your child, the other parent of your child, are no longer together, that's obviously, if you're together, you probably don't have a written agreement, right? If you guys break up at any point, and you do come to an agreement, put it in writing, that's great. But also ask a court to what's called so order it, where basically you're registering this written agreement with the court. Had that happened in this case, everything would have been so much simpler. I would have taken the Canada agreement that they had with the court order from Canada, because basically it means that the court has reviewed it and it's a valid agreement and an enforceable agreement. And the federal law, which is called the Uniform Child Custody Jurisdiction and Enforcement Act, or the UCCJEA, which is what New York has adopted in 49 other states, says that a foreign country is treated as a state for the purposes of this act. And that means that just like if you had a custody agreement with California, you'd be able to enforce it in New York. If you have a custody agreement from Canada, you can enforce it in New York. So same type of thing. But when you have a written agreement that hasn't been so ordered by a court, now the question is, well, what happens when the child's being withheld from you? Now, this is considered a child abduction in the sense of being wrongfully withheld. The child wasn't wrongfully removed from dad. The child was wrongfully withheld because she was supposed to be returned. So even if everything is going smoothly with the other parent, to prevent any future problems, go to the court, enter it on the record. If the other parent opposes, it's for both of your protection. Because, like I said, I would have taken that order, registered it with the court here, asked them to enforce it, and they would have made sure it substantially conformed with the laws of our country, which it did, and then they would have had to enforce it. And my client would have saved a lot of money. Instead, what we had to do was look at what our other options were. So there is, number 1, the Hague Convention. You may have heard of the Hague Convention before. I've mentioned the Hague when it comes to immigration, but there's also a part about child abduction. And this entire purpose of this part of the Hague Convention is to help parents who have their children wrongfully removed or retained in another country. That's a part has signed on to the Hague. So this doesn't help if they go to a non-Hague country, but it helps them when they don't have an enforceable agreement that they can quickly get their child back. And the Hague will make a determination. They determine, okay, this case applies to you. So you have to the child has to have been removed from their habitual residence, which isn't defined and is a little confusing, but let's just go past that because giving that explanation is going to take too long right now. You have to be exercising your custodial rights at the time, and that really means that, like, you can't wait, not see your children or talk to your children for 10 years and then suddenly say the child's being withheld. So in this case, the father was definitely exercising his custodial rights, and your child has to be under the age of 16. Those are the requirements for the Hague to apply and for the Hague to even help you. Now, it's great that the Hague Convention exists and they have this child abduction provision. However, the problem is that each country has a different level of compliance with this order, and each country takes a certain amount of time to come to a decision. Now, if the country decides, if Canada's, it's called the central authority, decided that the child was wrongfully retained, then I don't know what's happening on my phone. If they did decide that, then they would have had an order to return the child, but you still have to go to court and get that enforced if the parent won't voluntarily return. Now, they do try to get the parent to agree to voluntarily return first. In this case, we tried that too with it, but it didn't go anywhere. And then The Hague also doesn't, they might say the child has to return, but they don't mention a time or a place. Like, they leave that to the courts where it's being enforced. So you can wait 6 weeks, you can wait 6 months for The Hague to make a decision, and then you have to go to court, and then you have to wait for that decision to be made. So The Hague comes in handy for sure, especially because you never know how long things will take when you're in any court. And this is specifically for people who haven't received initial custody determinations, which means any court order from a court of competent jurisdiction that substantially conforms to the laws of the United States. So anyone out there who shares custody with another parent, who either has an oral agreement or a written agreement that they never went to court to put on the record, that's who this really helps. And we did speak to The Hague, and they did say this was a Hague case, but they said this is going to take a while. So your best bet is what we were simultaneously doing, which is what happened today, which I'm getting there, I promise. This is a complicated case. This is really, I've been immersed in this case for like the past 2 weeks. So what ended up happening is, when mom didn't return the child on the 26th, the Canadian attorney went up to Canada. Didn't go up to Canada, sorry. I'm getting a million messages, of course, so I'm getting distracted, but he's in Canada. He went up to the Canada court and filed an emergency petition to get custody and to have the child returned. And that was scheduled for this week. And at the same time, we knew there was this other custody petition, but we had no way of knowing how long Canada would take to make a decision. It was possible that I think the court was on Tuesday, that the judge could have, I'm not sure if they're called judges up there. I think not Barrett, whatever they're called up there. I apologize. My brain is, but the equivalent of the judge up there could have possibly ordered the child return on Tuesday. We didn't know, or it could have taken a lot longer. In this case, on Tuesday, the court gave they did appear, the mom and a hired attorney up there, they appeared, and they were given until next week to file an opposition. And then they were told, and then my client's Canadian attorney was told, you're going to have a chance to reply, and then I'm going to schedule you for oral argument, and then I'm going to make a decision on jurisdiction. So that timeline was, there wasn't real timeline. They're supposed to be expeditious, just like we are in our courts with these matters, but expeditious doesn't always mean that expeditiously. So at the same time, we were hired shortly after the Canadian paperwork was initially filed, and we looked at what our options were, and we could have gone to federal court or state court. So we had to make that decision. We decided state court because of the procedural device that we decided to use. The family courts are more familiar with than the Supreme Court. In New York, the Supreme Court's the civil court, not the highest court. the trial court. And also, if the Hague Convention did issue an order to return the child, the federal courts can't enforce it. It had to be in the state court, so it made more sense. So what we filed was called a writ of habeas corpus. Now, you may have heard that term before, usually in the context of a person who is imprisoned. So what it means in Latin is to show the body. And in the case of a child abduction case like this, basically it requires the other parent to bring the child before the court, to make sure the child's okay. And then I'll get into in a second what else it helped us do. So this was not any, we had to put in a lot of evidence here to really prove our point, and including all the paperwork that had already been filed. And we also had to make it clear that we are not saying New York has jurisdiction over the custody matter. We're saying there is a special clause in New York law, New York Domestic Relations Law 75-C, which states that even if there is no order to enforce, if the child's being wrongfully withheld, so that would be in either a removal from the other parent or, like this case, a retention, not returning the child when they were supposed to, then the court can first and foremost order the child and the parent who removed the child to appear before the court. And second, it gives the court the power to have very limited temporary emergency jurisdiction to issue an order to return the child and even a temporary custody order while the other cases are pending, until the court, whichever court has jurisdiction, takes over and issues a superseding order. It is a clause I've never had to invoke before, and I don't even think the judge on Monday knew about this clause. So Monday we file it, and then about an hour later, this is the one procedural device that really is handled expeditiously in New York. An hour later, me and my client were in front of a judge. It was, all virtual, and we had to explain what the issue was. And the judge seemed a little doubtful. I think she wasn't that familiar with the provision. Maybe she was, but I submitted a 208-page submission to the court. So my bigger assumption is not that she didn't have knowledge or wasn't sure, but that she didn't have enough time to really read everything I wrote. And the emergency, when you do a jurisdiction argument, the emergency provision is the last part of that argument. So I had like a 20-page memo of law explaining it, and then all the evidence. So I don't think, understandably, she was able to. But she asked my client, to explain the situation. I explained the law, and then she says, okay, I'm going to issue the writ, which means that she's granting that part of the case, meaning that she's requiring mom and child to appear before her. And she said that it had to be today. Now, she did say virtually, which is fine, especially because, we didn't expect the child to be handed over to my client today, since he would have had to be here for that to happen. But also, we really weren't sure what was going to happen, because I had to serve the opposing party and the New York attorney, which I did. I heard nothing from the other side. I didn't even know if they would appear. I wasn't clear if the judge was going to issue any type of order, any return or anything. I wasn't sure what their defense was going to be, if they were going to have one. There aren't too many defenses to this, but there can be. You do have to show an imminent risk to the child. And, wrongfully withholding the child from the other parent alone is actually considered child abuse, because of how psychological and emotionally damaging it can be. So there were other factors here too that I don't need to get into, but that's the thing, we really didn't have to get into. She was basically, mom decided that she wasn't going to give the child back to dad because she wanted to have primary custody and wanted the case to be in New York she didn't even really make a good faith effort to negotiate before their written agreement expired. So we get to court today, and my client was very nervous. And this was after what happened up in Canada, which his attorney in Canada said, I think overall is positive. The judge seemed to incline that he was going to take jurisdiction up in Canada, which I do believe, based on my knowledge of the case, that that's the right choice as well. But understandably, the client was frustrated. He hadn't seen his daughter since September. He was really stressed. Like he took it really hard. He really missed her, and he was really worried about her. There was a lot of reasons to be worried about her. So when he got out of court from Canada after our court on Monday, and the judge was pretty rough on him on Monday, and I told him that's just kind of how judges are sometimes, but not having a timeline, not even having any idea when his child was going to be returned to him, he was pretty down, understandably. Fortunately, that's about to change because we got to court today. First thing, the judge asked to see the daughter. She comes on camera, and the first thing she goes, "Dada, Dada," because she could see him, and she was so excited. And my client actually had to fight. He started tearing up and had to fight it back because he really does miss her so much. And then we sent, the child out. She was okay, And then the judge was like, "All right, well, I don't even need to get to the issue of if you actually had an agreement to return the child on December 26th. You guys were splitting the custody of the child evenly. That wasn't disputed. Why?" Basically asked the mom, and the mom's attorney, "Why didn't you return the child?" And they really had nothing. Basically, their claim was there was no agreement, and they were worried dad was going to hold on to the child, not give custody, or not, do the switching off again, because they never had a new agreement in place, and they was going to get jurisdiction in Canada, blah, blah, blah. And the judge says, "So you're worried that he's going to do what your client's doing right now, which is not return the child." And they tried to say that they should have had an opportunity. The attorney tried to say I never served her, which I had emailed proof of. The attorney then tried to say that we offered. Thank you, Usman. I will keep up the good work. They tried to say that they want an opportunity to respond to the writ. The writ was granted already. That's why we were in court. And the judge was like, that doesn't matter. They tried to say that, we offered him an agreement. We offered many things. And the judge, well, what did you offer? And she said, we offered that if he agrees to jurisdiction in New York, he can have the child for the next 3 months. And the judge is like, well, what makes your client think that she has the right to decide that? Like, she's basically forcing him into an agreement. And then they tried to say, well, then we offered that he can have visits in New York if he gave mom the passport for the child. And again, the judge was like, why? What is the concern? And they're like, that he wouldn't return the child. And she was like, but he's always returned the child. There's no reason. And so then the judge said, the only reason the dad shouldn't have the child right now is if you have an actual safety concern. Now, I already knew there were no safety concerns because they would have raised it in their custody petition. So the judge asked, what's your safety concerns? What's your safety concerns? And they didn't have any, and they couldn't answer the question. And, I learned very early in my career that when things are going your way in court and the judge agrees with you, you keep your mouth shut. So for 45 minutes or an hour, whatever we were in there, I didn't say too much. I just kind of let the judge rip on the other attorney who kept she was a young attorney. She was only I think I looked, she only a few years of experience, but I don't think she really understood what the writ of habeas corpus was. A lot of attorneys don't, because it's so rarely utilized and utilized properly. But she was trying to fight for her client, but her client was in the wrong, and sometimes your client's in the wrong and you can't change that. I mean, that's what the facts are. So she kind of was talking fast, going on, and the judge wasn't having it. So, to our delight, at the end of the hearing, or actually this was not even at the end because the other attorney kept trying to fight it, but the judge ordered that the child be returned to dad. And I asked the judge, I said, I requested that she keep in mind that he hasn't seen his daughter since September, and if she can put on the order, as soon as possible for the child to be returned, that would be ideal. And she agreed, and he will be picking her up. He's driving 10 hours tomorrow to pick up this child in New York, and he will have custody until, well, it's not even technically custody. She didn't even put in the order. She didn't have to put in the order custody, but she put that he will maintain possession of the child until a court decides jurisdiction or a superseding order is issued. And that's exactly what we wanted. Because we knew we didn't want a custody termination from New York. We weren't asking for that. We weren't asking for jurisdiction. We were only, because that's what the judge kept telling me Monday, I don't have jurisdiction. If you're telling me I don't have jurisdiction, I can't do anything. And I said, no. We have this temporary emergency provision. You can, in this limited circumstance. So my client is incredibly happy. I'm incredibly happy because honestly, we weren't sure what the judge was going to do. She could have let mom hold on to the daughter while it was pending too. I don't think that would have been right because mom should have returned the child already, but you never know. I've been unpleasantly surprised in court many times. I've been pleasantly surprised many times as well. And in this case, I think the judge had time to read over the filing and fully understood what her temporary emergency powers are. I got a little message. Happy, good people. Happy to you all. Thank you, Abdurrahman. Thank you for watching, and everyone else who's watching out there right now. As you can see, I'm very excited about our win today. This was a person, my client, who thought he might not see his daughter for months. He just didn't know. And then all of a sudden, bam, he has an enforceable order from New York State to come pick up his daughter tomorrow. And if that child is not turned over tomorrow, he can go right to the police, and they will go right back to that residence and order the child to be given to him, or somebody's getting arrested. And we don't want that to happen. We just want both parents to be able to have a relationship with the child and be, my client never wanted to withhold the child from mom. He's had his issues with her, and he has some concerns about her and her parenting, but that's not a reason to withhold her, and he never had. So the goal between now and whenever a court decides jurisdictional, or even after the court decides jurisdiction, is to try to reach an agreement between the parties to allow them, the daughter to see both parents, and then they need to decide where the daughter is ultimately going to live, and that's just what it is with joint custody. So to wrap up, I'm really excited about today because of how unique this case was, how hard it was. And there's just, it's hard sometimes to step away emotionally from a case. And, I could tell from my client's face and how tough it was on him and his family. And we have learned here today that if you and the other parent of your child separate at any point, things aren't going well. A written agreement, definitely. Don't run to, I'm not telling you to run to litigate the issue, because that's not ideal. Ideally, you guys negotiate, you enter an agreement with an attorney, without an attorney, regardless, and you get something in writing. Now take that writing and go to a court wherever you reside at the time, and get that court to review it, make sure it complies with the law, and then enter it on the record and give you what's called a so ordered written agreement. Because if he had that, it would have been, I would have been able, this petition for a writ of habeas corpus would have still been the proper vehicle, but instead of a 208-page filing, I could have just put a copy of the written agreement and the order from whichever jurisdiction issued it, and told the judge the daughter wasn't returned as she was supposed to, and that would have been the whole thing. It would have been a lot less stressful. So always do that. And also, it can be stressful and it can be expensive if you have to deal with something in two jurisdictions. And in this case, the client was lucky because the child was brought to a Hague country. And if you go to a non-Hague country, which I've dealt with in other cases, even if the Hague orders the child return, even if a state court or the federal court, whoever orders the child return, that country, there's most likely will not abide by that decision, because they've never agreed to abide by the decisions of our courts for this purpose. So that's why it's so important, because if you have an agreement on the record, you can also put in there preventative measures so that this child is not taken to a country like that or even kept from you. You can put alerts on the passports. You put provisions in there that are enforceable that says they can't leave the jurisdiction without your consent. You can determine who holds the passport. There's all different ways to do. Like right now, part of the last part of the order from today was that the child cannot be removed from Canada or the US, because she is a dual citizen of both. So that was a really a lot that I just said, as brief of a wrap up as I can give for a gigantic case like this. So I hope I was clear and that this is useful. But again, get your order entered on the record, and even if everything's going well, because you never know. The stories always start with everything was going well until, and don't wait till until, do it before. And if you are unfortunate enough to be in a situation like this, make sure that you find an attorney who understands the Hague Convention, understands the interaction with the state law where your child resides, and the other country or state where the child was taken, because that's going to be critical. My knowledge of the law was what won us the case. Also, all the work I did to make sure we documented everything. Oh, and there's one more important thing I wanted to say. One of the things that I think helped us here tremendously with the evidence is that mom likes to post her life on Facebook. So she tried to claim that she's resided in New York her whole life, and specifically the last 5 years. She's permanently resided there. But we know the child lived in Maine, California, New Jersey, and then most recently New York. And instead of it turning into a he said, she said type of thing, all we had to do was take her screenshots from her Facebook and Instagram, because she would say where she is. I'm in, California, and was her and the daughter, and finally, and would even say things like, finally reunited, at our apartment in New Jersey. So she kind of buried herself, and it was a little funny to see that right after she was served with the paperwork, she either deleted her accounts or blocked or made it private, because I was able to see it too, even not being friends with her. But that can technically obstruction of evidence, but we didn't have to get into that. But the point is, be careful what you post on Facebook and Instagram and any social media, because it can be used against you. And guess what? Even if you delete it, it doesn't mean it's deleted, because I still have the screenshots. And there's something called the Wayback Machine, which is like a website where if it ever existed online, you can find it. So remember that. Everything lives forever in the cloud, as they say. So that is really all for today. If you are in this situation, God forbid, or know anyone who is, we're here for you. Our contact information has been rolling across the bottom of the screen on YouTube and Facebook. On Instagram, if you go to our bio page, you'll find it there. Don't forget to like us and follow us so you don't miss any more of our lives. And of course, if you found this to be helpful or know anyone who may, please hit that share button. That is all for now. Thanks for watching. Have a great day and a great weekend.